If you would be quiet, those words from DHS Secretary Kristi Noem just exposed everything wrong with Trump's approach to constitutional law. What you're about to see is Congressman Dan Goldman systematically dismantling Noem's refusal to follow a unanimous Supreme Court ruling revealing how she's choosing political loyalty over the rule of law in real time.
I now recognize Mr. Goldman for 5 minutes questioning.
Thank you, Mr. Chairman. I would like to go back to Mr. Kilmar Abrego Garcia's case, Madam Secretary. But my first question for you is a pretty simple one. It's basic civics. Which branch of government does the Constitution give the authority to interpret what the law is, the judiciary or the executive branch?
Sir, going forward, the interpretation of the law, you make the laws in this body. The judicial branch makes sure that they have integrity and they're applied properly to individuals.
So I'm just going to take that as the judiciary branch. Now, let's focus for a second on what the judiciary branch has said about this case. We know the Supreme Court has said 9-0 that notwithstanding your statements under oath here today that Mr. Kilmar Abrego Garcia was afforded due process, he was in fact not afforded due process, because then if he were, you would have seen the withholding order that did not permit him to be deported to El Salvador. Now you allege, and I guess the Attorney General alleges, that he's a member of MS-13. That may very well be the case. And if he is, now that that is a foreign terrorist organization, certainly the immigration laws would allow him, and in fact require him, to be deported. I certainly would support that. But the problem that we have here is what you allege, what Ms. Green alleges, what the Attorney General alleges, is not the judiciary. You don't get to decide whether or not he is an MS-13 member. And you don't have to take my word for it, because Judge Wilkinson, a Fourth Circuit judge, very conservative, addressed this argument. He said, the government asserts that Abrego Garcia is a terrorist and a member of MS-13. Perhaps, but perhaps not. Regardless, he is still entitled to due process. If the government is confident in its position, it should be assured that position will prevail in proceedings to terminate the withholding of removal order. Will you commit right now to give Mr. Abrego Garcia that process where you can prove your allegation that he is a member of MS-13?
Congressman, that judge that you just quoted did not say he was not a member of MS-13. Who did say that he was a member of MS-13 was law enforcement officers that encountered this individual.
Yeah, he knows that. This is a Fourth Circuit judge. He knows all of what the evidence is, and he's saying if that evidence... So you're not going to commit to follow this order? You won't commit to follow this court order?
By the way, he identified
Madam Secretary,
himself.
I reclaim my time. Stop filibustering.
He was surrounded by gang members of MS-13.
Will you give Mr. Abrego Garcia the due process that the Supreme Court and Judge Wilkinson has required you to give him?
Abrego Garcia is an El Salvador resident who is in his home country. If he were to come back to this country, he would be immediately removed again.
How do you know?
He has received and been treated appropriately,
so
sir, and he is not.
How can you say he's been treated appropriately if the Supreme Court has ruled 9-0? 9-0 that he hasn't been treated appropriately? Why is your opinion better and have more authority than the Supreme Court?
Investigators, 2 judges, an immigration court that all said he was MS-13 and was removed from this country.
But you understand, that is you saying that. That is you saying that.
That is them saying that. This
no.
investigators and law
that is
enforcement
you making that
the case
determination.
They built against him. If you don't
the
trust our law
court
enforcement
has considered all that. The judge has considered all that, Madam Secretary. And if you would be quiet, because I'm reclaiming my time, you are not following this court order. But let's focus on the court order, because this opinion also says that to facilitate, which the Supreme Court is requiring, is an active verb. It requires that steps be taken. What steps have you taken to return Mr. Abrego Garcia to allow him to get due process?
Abrego Garcia is in his home country.
What
If he were to come
steps
back here,
have
your
you
advocacy-
taken?
If your continued advocacy for him were to...
I'm not advocating for him.
Yes, you
I'm
are.
advocating for a
Absolutely.
court order, Madam
Gone to the
Secretary.
mat for this
The
man
court
who
order
has terrorized
says
people
that
in
you
traffic
must take
with human
steps
beings.
to follow the court order. You are here under oath. What steps have you taken to return Mr. Abrego Garcia pursuant to this court order?
It's got to be extremely discouraging to be one of your constituents. To see you fight for a terrorist like this and not fight for them is extremely alarming to me.
I'm fighting for due process,
constituents as
and that's under the Constitution.
The gentleman's
and you
time
should
has
fight too for due
expired.
process.
The gentleman's time has expired. I now recognize.
What just happened in that hearing wasn't just a heated exchange between a congressman and a cabinet secretary. It was a masterclass in how constitutional principles either hold or crumble under political pressure. Dan Goldman's methodical questioning of Kristi Noem about the Abrego Garcia case revealed something far more dangerous than bureaucratic incompetence. It exposed a fundamental rejection of judicial authority. Goldman started with basic civics. Which branch interprets the law, judiciary or executive? Noem's answer revealed the problem immediately. She acknowledged the judiciary's role, then spent the rest of her testimony ignoring it completely. That contradiction isn't academic hair-splitting, it's the difference between constitutional governance and authoritarian drift. The Supreme Court ruled unanimously that Garcia was denied due process. Unanimously means all 9 justices, conservative and liberal, agreed that the government violated his constitutional rights. When Goldman pressed Noem on this, her response was telling. She didn't dispute the ruling, she simply ignored it, insisting that law enforcement officers had determined Garcia was MS-13, as if that determination superseded judicial review. This matters because due process isn't about protecting guilty people. It's about ensuring the government follows consistent rules when exercising power over anyone. When officials decide they can skip judicial oversight because they're confident in their conclusions, you've effectively eliminated the checks and balances that separate constitutional republics from police states. Goldman then quoted Judge Wilkinson, a conservative Fourth Circuit judge, who explicitly stated that even if Garcia is MS-13, he's still entitled to due process. Noem's reaction was to deflect, claiming the judge didn't say Garcia wasn't MS-13. But that misses the point entirely. The question isn't Garcia's guilt or innocence. It's whether the government follows legal procedures regardless of who they're dealing with. The most revealing moment came when Goldman asked what steps Noem had taken to comply with the court order. The Supreme Court had used the word facilitate, which implies active measures. Noem's response? Garcia is in El Salvador, implying the problem had resolved itself. That's not compliance. That's hoping geography makes constitutional violations disappear. When Goldman pressed harder, Noem resorted to personal attacks, suggesting Goldman was fighting for terrorists rather than constitutional principles. That rhetorical move is classic deflection. Reframe legal questions as loyalty tests. It's the same logic that turns judicial oversight into obstruction and constitutional compliance into weakness. The phrase, "if you would be quiet," crystallized the entire exchange. Goldman was reclaiming his time, a standard parliamentary procedure. Noem treated it as an interruption she could dismiss. That small moment reflected a larger attitude. Institutional norms and legal procedures are inconveniences to be brushed aside when they conflict with political objectives. This case illuminates 3 broader problems. First, selective constitutional compliance. When officials pick and choose which court orders to follow based on political convenience, the rule of law becomes conditional. Second, the weaponization of security concerns. Labeling someone a terrorist doesn't exempt the government from following legal procedures. If anything, high-stakes cases demand more rigorous adherence to constitutional safeguards. Third, the erosion of inter-branch respect. When executive officials openly dismiss judicial authority, they're not just defying individual rulings, they're undermining the entire system of separated powers. The consequences extend beyond this single case. Career government lawyers notice when constitutional compliance becomes optional. Federal agencies adjust their procedures accordingly. Other countries watch how America treats legal norms and modify their own expectations about international law and cooperation. Goldman's persistence in this hearing wasn't about defending one individual, it was about defending the principle that government power operates within legal constraints, not above them. When that principle erodes, the distance between constitutional democracy and authoritarian governance shrinks rapidly. The choice isn't between supporting Garcia or supporting security, it's between supporting a system where law constrains power or accepting a system where power defines law.